Urgent. XRP Ripple lawyer's statement changes course of trial. Is it possible to relist XRP on Coinbase? What will such an event lead to? We will answer these questions in today's video. The current price of XRP for today is $0.35 and the trading volume for 24 hours is $136,000,000 We are updating our XRP price in US dollars in real time. XRP has dropped 30% in the last 24 hours. Welcome to the Rich Club channel. If you like this video, don't forget to like it and subscribe to the channel. Do you think the analysts are right about XRP? Write the answers in the comments. Giving away 500 XRP at the end of the week. One random subscriber will receive XRP coins. Take a look at the instructions in the comments section. All you need to do is write the word XRP, watch the video to the end to like and subscribe. The recent move down the channel has forced XRP to fall below some vital price points that the coin recovered last week. Alt pulled back more than 16% from July 8th and reached its 3-week low on July 13th. Over the past day, the altcoin has bounced off 16-month support near the $0.3 mark. But the Fibonacci resistance of 23.6% weakened the break above the descending channel. Given that the 50-day EMA, blue, creates obstacles to recovery, the recent pullback may help sellers retest the upper trend line of the descending channel. In this case, XRP may bounce back from the $0.31 zone in the coming sessions. The control point, PLZ red, can lay the foundation for buyers to intervene and retest the level of 23.6% near the $0.324 mark. An immediate recovery above the baseline will help buyers test the 23.6% level around $0.32. Attorney James Phelan shared a heavily redacted letter filed by the SEC. He demanded that Judge Torres revoke the Amici status granted to XRP holders. The letter also mentioned the restriction of John Deaton's participation in the case. According to the SEC, Deaton tried to enter into a lawsuit, including seeking a court order in another court on his behalf. The commission stressed that in the lawyer's Twitter feed and public statement, movements are XRP investors who believe that this case has reduced their profits from the token. It mentioned that back in October 2021, the court rejected Movement's request for intervention and granted Movement Amici status. This required them to get court permission to file an amicus brief. However, when refusing to intervene, it was concluded that this would delay or damage the consideration of the rights of both parties. The watchdog offered 5 reasons to reject the move. One of them says that Movements does not hold briefings on legal issues. Instead, they present arguments based on 3,252 affidavits from XRP token holders. Responding to the SEC's statement, John Deaton said the commission had put forward the same nonsensical argument to Judge Netburn. According to their theory, every person selling XRP has violated Section 5. However, exceptions apply only if XRP is a security. He added that any person who has the intention to sell XRP can be considered an issuer. That's why exchanges won't refloat XRP if it's called a security, Deaton added, which is a zero-sum game. Brad Sherman, the subcommittee chair, said, "If XRP is a security, and you think it is, and I think it is, why are these crypto exchanges not in violation of law, and is it enough that the crypto exchanges have said, well, having committed tens of thousands of violations in the past, we promise not to do any more in the future? Is that enough to get you off the hook for enforcement?" Essentially, the chair noted that crypto exchanges in which XRP token was trading during the period in question should all be sued. Sherman asked in the hearing, "The SEC has gone after XRP tokens for trading illegally as security. However, none of the exchanges that earlier listed XRP has been sued." Sherman also mentioned that it appears that the SEC is going after the small fish rather than the big fish. The big fish exchanges have completed tens of thousands of XRP transactions, meaning they illegally traded securities. During the hearing, an SEC representative was given a chance to respond to the questions raised by Sherman. Gerber Grewal, the SEC enforcement director, said he can't respond to what matters we are looking at or not looking at. However, he highlighted that the SEC brought charges against Poloniex for dealing with unregistered securities. Grewal mentioned that the regulator has already strengthened the crypto-focused enforcement teams but said it's inappropriate to make further comments. There is an ongoing case between the SEC and Ripple that began sometime in 2020. The regulator accused Ripple of not registering XRP worth around $1.4 billion as security. But, the Ripple network has maintained that its XRP token is merely a utility token used in payments and not simply a speculative asset. A few weeks ago, Ripple CEO Brad Garlinghouse noted that their case with the SEC had gone exceedingly well. However, he also mentioned that the network would leave the US if they lost the court case. Ripple is not the only crypto network to face a spat against the SEC. Last September, the SEC threatened Coinbase with legal actions for launching any crypto-focused lending services. Coinbase intended to establish a lending program that would allow users to earn interest. However, the SEC declared that this new product would require government registrations. Others like Binance, BitMEX, Poloniex, and Robinhood also found themselves on the wrong side of the SEC. Projects planning to launch crypto-focused spot ETFs are still struggling since the SEC is constantly rejecting every application. The U.S. Securities and Exchange Commission, SEC, is trying to block the holders of Ripple, XRP, from helping to protect Ripple and prohibit attorney John E. Deaton from any further participation in the proceedings. In its official objection submitted on Tuesday, the regulator, together with lawyer John E. Deaton, opposed the decision to recognize 1,746 XRP holders as Amici curiae. Amici, plural, Amici curiae, means friend of the court, an individual or organization who is not a party to a court case, but who is allowed to help the court by providing information, experience, or ideas. In this case, in support of Ripple protection. Deaton has 3,252 affidavits signed by token holders, which essentially state that they are victims of an SEC lawsuit against Ripple as a result of lost profits. The holders claim in written testimony that they either did not take legal responsibility for the purchase of XRP, or bought tokens for utilitarian purposes and not for investment purposes, or did not buy on the basis of promises made by the company and its representatives. However, in its objection to XRP holders, the Commission stated that they were trying to act beyond strictly legal issues. SEC writes, Movement does not offer instruction on legal issues. Instead, they want to present arguments based on 3,252 affidavits confirming certain facts. The Commission cited Deaton's alleged threats against former Securities and Exchange Commission Chairman Jay Clayton as grounds for firing him from his amicus position. The Securities and Exchange Commission included an edited letter to Judge Torres dated June 7, quoting a YouTube video from 2021 in which Deaton stated that he may have to come up and slap, profanity, to former chairman of the Securities and Exchange Commission Jay Clayton. Holders of XRP and Deaton as Amici must submit a public response to the SEC's objection by July 25. Ripple is a blockchain company that issues the XRP token. The SEC said in an ongoing court case that began in 2020 that Ripple and its executives Brad Garlinghouse and Christian Larson sold XRP as unregistered securities. Deaton questions SEC's treatment of McCaleb. Meanwhile, Deaton stated that the SEC inconsistently applied the law against Ripple, Garlinghouse, and Larson. On Tuesday, in a tweet, the lawyer explained that if the SEC really considered XRP a security, it would have filed an injunction against Ripple and issued an order to stop and refrain from selling its tokens to two executives and Jed McCaleb. Ripple co-founder Jed McCaleb has sold 9 billion XRP since leaving the company in 2014. The SEC claims that #XRP itself is a security, and anyone who sells it violates Section 5 of the Securities Act. The Securities and Exchange Commission claims that at Ripple, at Garlinghouse, and at Chris Larson's enriched themselves at the expense of investors, and demands recovery of $1.3 billion from these defendants. The outcome of this case may determine whether XRP is a security. If the judge rules in favor of the SEC, this may become a precedent necessary for the Commission to file a lawsuit against other crypto projects that sold tokens similarly to Ripple. What do you think are the prospects for XRP in 2023? Write your forecasts in the comments. Thank you for watching this video to the end. Please do not forget to like it and subscribe to the channel so as not to miss the release of new videos, and do not forget about our contest. Write in the XRP comments to add 500 XRP to your account.